Good morning, everyone. Good afternoon, depending where you are. We're going to continue our conversation about blockchain laws with Louis today. Louis Cohen has been a guest on my show a couple of times now. He's a repeat guest because he knows quite a lot about very complex area of law and related to blockchain and securities. Today, specifically, we're going to talk about enforcement and civil litigation. I am so excited to have this conversation. Then we're going to geek out about enforcement and civil litigation and SEC. Please reintroduce yourself so folks have understanding who you are and where you come from.
That's very kind, Olga. I couldn't be more happy to be back with you on the show. And you do such a great job, explaining things and making difficult concepts clear. It's a real pleasure. So my name is Louis Cohen. I am a co-founder of a law firm based mostly on the East Coast, DLx Law. We have offices in New York City, Wilmington, Delaware, and Washington, D.C. And we focus on clients working in the crypto, blockchain, digital asset space. We do a lot with NFTs, with decentralized protocols, and also with permission protocols as well, which I think still, can have tremendous value. And we're pretty active across all areas, especially because we're going to be talking about litigation. Just one point to emphasize, I'm not a litigator, so that's really important to know. So if I make stuff up and like real litigators listening say he doesn't know, call me out. It's totally fair. I'm a transactional lawyer, but we observe the litigation that goes on, and it obviously both on the enforcement side from the federal and state levels and at the civil side, it has a huge impact in what we do, how we advise our clients, and how we decide to proceed. So it's really important to understand that side of things in this space, even with the caveat that I'm not actually a litigator. I don't even play one on TV.
But I think at this point, let's talk about SEC and its approach to enforcement. It's very unique. What is it, and what has it been, and how's that involved, and where are we going with it?
All right. Well, there's a lot to cover. We'll break that down. Let's start at the beginning, which is probably the best place to go. And I think some of this, I feel like we might have touched on in an earlier episode, but not everybody saw every episode. And it's important to start at the beginning. So as digital assets became more popular, and again, we're not talking about here about like other litigation involving Bitcoin, like Ponzi schemes involving Bitcoin, things like that. Those are interesting, but not really relevant to our primary purpose here, which is securities laws and digital assets. So just also make that caveat. The first big step that the SEC took, and for those following the space, you're probably very aware of it, was something called the DAO Report. And so the DAO, again, many of you will be aware of that, but the DAO was a very early Ethereum-based project that involved setting up what was functionally a decentralized venture capital fund. So the idea with the DAO, as it was called, is you would put ETH into effectively a wallet and a smart contract, I should say, and potentially as a result of getting back interest in the DAO, be able to vote on investments, and then where people could apply, and the money would, or the value would go, and hopefully build an ecosystem. In any event, it all worked out very poorly because right at the beginning there was an exploit, and that's another very long and interesting story. But in any event, as a result, the project unwound before it could ever get going. A year later, in the summer of, I believe, 2018, it was 2017, 18, that was the summer of 2017, excuse me. The SEC came out with a report. And what's interesting about this, Olga, is that nobody was charged. This was not an enforcement action. It was the proverbial shot across the bow. So the SEC spent the year looking back at what happened with the DAO and tried to use that as a jumping off point to give the SEC's perspective to the market. That is basically what they saw with the DAO, independent of the exploit that brought it down, was a security scheme. People were putting value into something that the SEC saw as a common enterprise. And even though it was nominally decentralized, the SEC analyzed the situation very closely and concluded that the German entity that had sponsored it had significant control over the smart contracts and the arrangements. And so as a result, and people recall from prior episodes, they had created what we call an investment contract or investment scheme in the US and had violated the law, even though no one was actually charged. So
the DAO report is very important in the history of enforcement. What is the implication of the decision and choosing to do the method that the SEC have chosen?
It's a great question, because it's hard to say. I don't know. I was not with the SEC. So I think probably optimistically, the view was if we tell the market where they're going wrong, the market would sort of self-correct and stop doing a lot of what they were doing. And probably the hope was maybe we don't need to take aggressive enforcement actions, perhaps by issuing this report, not charging any individual actor. Market participants would kind of get the message that many of the arrangements in which digital assets are sold could constitute investment contracts, unregistered sales of securities, broadly speaking, cut it out. That was probably the optimistic hope. I think maybe a little more cynically, you might say that the staff figured by issuing a report, it also put people on notice. So if actors continued doing things that, at least in the mind of the SEC, were violating the law, now they couldn't say, hey, I just didn't know. Nobody told me. I couldn't figure it out. It's really complicated. Because here we have a report issued by the SEC, by the commission, stating this type of activity involving sales of digital assets under these circumstances probably is violating the law, and we're putting you on notice on that. So I think the purpose here was to put a marker down in a relatively gentle way, try and dissuade people from going down the wrong path, and putting a pin on the wall for those who did do something wrong that they could go back to and say, look, and they did in fact go back to them and say, look, we issued this report, you were on notice, you did it anyway, you have a higher level of culpability.
So that sounds like it started precedent.
Yeah.
It started a trend.
Yes.
So from then to today, what has happened in the middle, and how is that sort of impacting the way the SEC guidance is shared and proliferated and enforced?
Well, so one of the challenges about the DAO report, and I can understand from the staff's point of view why they might choose that project as one to go after. It had the, coincidental, it was very large at the time, and it had the coincidental benefit of never having gotten going because of the exploit, which was independent of any securities law problems. And so I could see why, it might look like a promising, sort of project to sort of use as set as an example. The problem, Olga, was that the DAO structure was very different from the quote-unquote ICOs. We talked about them a lot on earlier episodes, the ICOs that were going on at the time. The DAO really did look like a securities arrangement. People were really investing money. They were expecting to get a return. It had all the hallmarks of a security. What happened is after the report, was like July of 2017, people said, well, I'm not doing what the DAO did. So I understand the SEC didn't like that, but I'm doing something different here. And so what happened after that is we could see to be continued, if not even increased activity along the lines of ICOs and token sales, with people rationalizing that rightly or wrongly and saying, well, I understand what the DAO did was problematic, but what I'm doing is different. So
it had the opposite effect.
Yeah. But I was going to add one more thing, if I can. The other thing is the SEC, again, I think being thoughtful about this, started the more active enforcement actions with fraud actions. So there was a guy named, I think Zaslavsky, in Brooklyn, New York, and he had two schemes that were pretty patently fraudulent. So he purportedly sold tokens. I think the first one was meant to be backed by diamonds, and the other was meant to be backed by something else, or real estate. The first one was real estate, and the second was meant to be backed by diamonds. There was never any real estate. There was never anything. He was just, he was a fraudster. And so he was hit with, I think, both civil and criminal charges, and ultimately, found guilty and responsible. That, I think, was, again, on the part of the enforcement authorities, something that they thought would send a message. But many, I think, market participants read it the wrong way and said, well, okay, don't do frauds. Fair enough. I'm not doing a fraud. So once again, I guess, I hear what you're saying, SEC, but it doesn't apply to me because I'm not doing a fraud. I'm not doing an investment fund like the DAO. So let me just be on my way. So at that point that was like September, October of 2017. At that point, I think the market had not yet gotten the message that the SEC is quite serious about this.
Yeah. So to where we are today, especially with the civil action.
Yep.
How does that all connect?
Well, that's a great question, and I think sometimes because a lot of attention has gone to the either federal or state enforcement actions, the civil actions have a little bit gotten kind of brushed aside, but they're equally important. I'll just say that the federal enforcement actions continued, and I think again on prior episodes we talked in particular about some of the bigger names, Kik, the Canadian social media company, Telegram, the messaging company, and then ultimately the enforcement action, the governmental action that's continuing to go on, which is against Ripple Labs, the issuer of the XRP token. So that's kind of the ongoing trend. There's obviously many other smaller but still relevant enforcement actions. But on the civil side, it's different. Interestingly enough, the same Ripple Labs attracted a civil lawsuit broadly along the lines of the enforcement a suit brought by the SEC, claiming that the sales of their security or their purported security, the XRP token, was in violation of Section 5 of the Securities Act of 1933 and therefore illegal. And therefore, the investors claimed that they had right of rescission and be able to get their money back. That, as best as I can tell, that private civil suit against Ripple Labs continues. It's going very slowly with discovery. Subsequently, there were a number of prominent civil suits against a large project called Tezos that had some real difficulties getting off the ground, and that suit went on. I think that suit against Tezos got settled, I believe, but that introduced some interesting elements. And then in what some people call the Red Wedding, there were, I think, 11 or 12 coordinated lawsuits filed in the spring of 2020 against a bunch of both different projects and exchanges by two fairly well-known plaintiffs firms. They were both spin-offs of other plaintiff law firms, trying to sort of do what plaintiff law firms do, which is bring securities claims. But those were different in that way. And they had about, again, 10 or 11 suits, and almost all of them got dismissed, mainly on statute of limitations ground, because, and here's really where it gets interesting, I would say, Olga, the claims that were brought were trying to go to the very narrow question, again, of this technical issue of having illegal, unregistered sale of securities. Those are difficult actions to bring in the civil side of things. There's a 1-year statute of limitations. There's very limited. There's less discovery. There's a lot of challenges, and so those actions didn't really go forward, or most of them, wound up getting dismissed. It'll be interesting to see where we go from there. But that was like the last kind of big push around private civil litigation.
So do you, it's having been on the project that had adventures was in this world, do you think the sort of the civil actions have legs, given that, we definitely see quite a lot of prominent action on the SEC, and we definitely see various AGs doing different things. But I would have expected that by now the civil litigation, the plaintiff's bar, it would have figured something out. Like that's kind of their job. That's what they do well and best. And this would not be their first rodeo. And yet, we're kind of still at the beginning. So what are your thoughts there?
It's a great question, and I think you're looking at it exactly the right way, Olga. The plaintiff's counsel, it's an interesting, sort of structure that we have here in the States, which is really different from what you have in common law countries and most of the other parts of the world, where we have this kind of like separate actor, which is the plaintiff's bar, and they, really are effectively delegated certain enforcement authorities as a practical matter. But they are very rational economic actors, to your point. the plaintiffs bar only go after cases that they think can provide an economic return, because the plaintiffs bar are not themselves the parties that had the loss. So if you've had a loss and you have unlimited resources, you want to go hire a lawyer and go after somebody, go to it, more power to you. But in most cases, the people who suffer the loss don't have the means to really pursue the claim.
Yeah, I mean, it's more than that. It's they make an economic investment, not just their time, but as a former litigator, I can tell you, litigating is costly. Things like depositions and filings, they have to put out-of-pocket costs for that, and which may not be insignificant. So they have to make it's a bet.
Absolutely, it's a decision. That's exactly right, Olga. And of course, over the last 10, 15, 20 years, whatever it's been now, we have this active market of litigation finance, right? So not only is it expensive, but other actors, financial actors, have stepped into the mix and said, wow, many of these cases can be quite profitable. We can provide the capital that plaintiffs' counsels need to go pursue these litigations, and the litigation finance teams are very adept at evaluating cases. So the capital gets attracted when a case shows some promise of a settlement. Now, what's interesting, in normal securities litigation, you've got a number of potential deep pockets that actually make the whole thing potentially interesting. First and foremost, the legal entity that made the violation, typically a fraud violation, material misstatements or omissions in the sale of a security. And so you've got the company itself as a potential defendant, often, with relatively deep pockets and available for settling. You then would almost always see the CEO and other senior officers, sometimes board members, depending, getting named. And one of the reasons you name those guys or ladies is that there will almost always be a directors and officers or D&O insurance policy that covers these things. So that's another deep pocket, whoever has provided the insurance. So you're now, as a plaintiff's lawyer, again, you're looking at a couple of deep pockets. Moreover, many transactions, not all, but many transactions will offer up third parties who are also deep-pocketed. The most obvious of which are underwriters who underwrite, investment banks that underwrote the sale of the securities, or auditors who audited the accounts if the accounts are alleged, like a WorldCom or something like that the accounts were alleged to be fraudulent. So there are a whole range of potential deep pockets. None of those actors are present in most of the digital asset offerings. There's no underwriter, there's no auditor of any financial type, whatever. Oftentimes, there's either no company or the company has exceedingly limited resources. And at least up until recently, there was certainly no insurance in most cases for those entities. And so one of the very practical reasons why we haven't seen as much civil litigation is it just wasn't very economic for those who make it, their livelihood of going after, people.
Where do you think this will go? I was almost certain that this would be a much more robust cottage industry today, back when I was in 2016, 17, 18, in this industry. And yet it kind of isn't. Where do you think we're going with this?
Well, we got a long way to go, Olga. So I hate to say it because I certainly am not rooting for litigation in any way, shape, or form. But I wouldn't be bailing out on this at all. It's in the nature of human affairs that when a lot of money is made and then it sort of shifts hands or money gets lost, that somebody is looking to hold someone else responsible. And so I think this will continue to be an issue as some of the projects have gotten very, very large. There are some new deep pockets. Either the public leaders of the project, who in many cases have become, billionaires, in short amounts of time, the companies, the sponsors, even potentially venture capital firms that have funded the projects and, taken large numbers of tokens. I think in most cases, there are not really good claims against them, but, that depends on facts and circumstances. So I think as the whole digital asset sector gets larger, as we kind of acclimate ourselves to the idea that rather than having economic activity happen through the vessel of a corporation, the vessel of a limited liability company, economic activity can happen through the vessel of a suite of decentralized, a suite of smart contracts that are not owned by any particular person, and values getting captured by tokens, not shares or other securities. And so I think we will see litigation, but it's going to have to adapt to this new and very different environment.
Do you think that, there's some interesting stuff going on with Ripple Labs and a few others? Coinbase has its own adventures. There's quite a few simultaneous adventures happening. Do you, I don't know if you probably want to give a brief summary of what's happening kind of on the forefront of the law here. But more interestingly, do you think that will have an impact on enforcement and civil litigation?
Well, it's a fascinating question because, the Ripple Labs case, and I think we talked about that in some depth in an earlier podcast or whatever we call what we're doing here. So I don't want to repeat too much, but basically, of course, the XRP token was one of the largest in terms of overall market capitalization, and right at the end of the chairmanship of Jay Clayton of the SEC did, after presumably quite some time of investigating, file an action against Ripple Labs, and that's been going on now for a very long, for many months, over a year, I guess. Gosh, the pandemic, I lose track of time, but well over a year, right? Because
time flies when you're having fun.
Exactly, when you're cooped up at home, indeed. So that's been going on, and Ripple Labs is very, they're very well capitalized, and they've been represented by very able counsel on the defense side, some of whom had spent significant time as senior staff members of the SEC itself. So, and that's been a long and ongoing battle. It's very difficult to say, and many people online prognosticate, there's going to be a settlement, this, that, the other thing. I don't, I don't know, and I think it's a little foolhardy to make guesses. But I think your larger question is really the important one, which is, where's this taking us? Where's this all going? And I think independent of whatever, happens to Ripple Labs, whatever becomes of the XRP token, we continue to struggle to develop the digital asset sector, the blockchain sector, the decentralized finance sector, all of these different things, even the NFT sector, where we have this thread of litigation hanging over market participants. And I think there hopefully will be a desire, maybe through Congress, to try and set some more clear rules of the road. And just since, of course, we did our last episodes, a number of proposals have been put out there. You mentioned Coinbase. Coinbase delivered a significant proposal, I guess, last week. I think Andreessen Horowitz, a major venture capital firm, submitted just made public a paper on policy proposals. Various, members of Congress have introduced legislation. I think we may have talked a little bit about a bill introduced by Representative Beyer of Virginia that had a kind of far-reaching sort of regulatory framework. So a lot of flowers are blooming in terms of proposals. What we need to see, and to allow us to move past this period of not just litigation, Olga, but the threat of litigation, right? The overhang of litigation, which to me is in many ways more stymieing than the litigation itself, because you just don't know where to turn.
Yeah. The lack of clarity is worse than knowing the predictable paths of litigation, because if you know where litigation will go, you'll just act according to what's logically happen and make rational decision. I think that uncertainty, that's probably the worst thing in the marketplace and innovation, more than even treble damages, so to speak.
Yes.
that really has a chilling effect, and inspires crazy and inspires inaction, and you want neither. You want rational people doing rational things. We'll talk about legislations. I just recently had somebody who is very actively talking to legislators and brings the community to DC, and there's quite a lot going on, and which I think is the reason why blockchain, it is such a legal product. There's so many opportunities for lawyers to be part of it. both in influencing the policy and legislation and actually advising clients. Let's talk about things like no action letters and their impact before we go to kind of where you think legislatively we're going with the enforcement and civil litigation. Just curious kind of how you think the role of that has an impact.
That's a great question. So as I think you know, and we might have touched on, our firm, DLx Law, had gotten one of the three no action letters in the digital asset space. The first was for a company called Turnkey Jets. And, it was a great first letter because what Turnkey Jets was proposing to do didn't really involve public blockchains, a lot of other things. It was pretty limited. Shortly after the SEC released the no action letter for Turnkey Jets, a couple months later, our no action letter for a company called Pocketful of Quarters came out. That was quite notable because it was the first time.
By the way, congratulations for those people who don't appreciate.
We've been going with that one for a while. So I'm ready to get something else going there. But in any event, that moved the ball forward in many ways because it was an ERC20 token of well understood digital asset project on a public chain, Ethereum, et cetera. But that also had limited benefits because one of the requirements was that functionally the token really couldn't trade in the way most digital assets trade. It was very important to the staff, and it looked like at the time of the first step that people weren't buying with an expectation of profit. And one way to make sure there's no expectation of profit is to make sure that the price of the asset doesn't go up or down for that matter, but in particular up. So that it was a great step, but it was a limited step. Then in November of 2019 or 2020, gosh, I think it was 2019, a letter was issued for a company called IMVU, and IMVU provided like a metaverse, sort of early metaverse where you can go and you have an avatar and kind of do stuff. And they were able to persuade the SEC that their in-game currency should be able to be traded, through a digital asset and traded outside of the system. But again, to ensure that the price of the asset didn't go up, they put in a number of features that really were limiting to the benefits of that no action letter. So that's the three no action letters that we have, to date in the digital asset space. I think there had been some hope. Gary Gensler was known for issuing quite a number of no action letters when he was the chair of the CFTC, the Commodities Futures Trading Commission. And so there was kind of a hope expectation that perhaps, new regulations are difficult, legislation's super difficult, maybe we'll get some no action letters that are helpful and will provide some guidance. That has not occurred to date. So that doesn't mean that there aren't some exciting, no action letters just waiting in the wings, but we haven't seen them. And it's been, now 9 months or so that the chair has been in place. So maybe a little less than that. But in any event, so I think no action letters may be able to move things forward, but to date, they have not been a particularly effective way of providing a pathway to avoid litigation, right? Our theme here is litigation and a pathway to avoid litigation. I do want to throw, before we move on to the last thing, the one last thing I want to touch about is just DAOs or decentralized autonomous organizations in general, as opposed to the DAO report.
Yeah.
So just give a minute on that because I think it really does tie in. I think what we're seeing a lot of projects saying is like we're aware of this, this litigation risk, either civil litigation or enforcement actions, and so we don't want to be in the line of fire. So we're just going to dissolve our legal entities, whether it's a foundation or even just a general Delaware corporation, Cayman Islands corporation. We're going to make those go away. We're going to dissolve them, and we're going to turn everything over, kind of give the keys to the inmates, as it were, to the people holding, the tokens of the DAO. And that's really, really interesting. And it raises, a lot of questions about, well, what is a DAO and how would enforcement either, at the federal or state level from a governmental point of view or in the civil space, how does that work? Who do you serve? Who's responsible for this? And so I think the growth and the development of the DAOs is going to have an absolutely critical impact on the litigation side, right? Because with, where you're
who do you go after?
Exactly right. So that's still a lot of that is to be determined. Many DAOs, might be viewed as unincorporated unincorporated entities or general partnerships. But again, the property, so for example, a general partnership, law firms, at least until recently, many law firms were general partnerships. They owned property, they had assets, they could take out bank lines of credit. So there's nothing that stops people to organize themselves under general partnership. But they still have an agreement. They'd have pretty clear legal relationships. And also they'd have assets, for the most part, that were in the real world and could be attached and taken away. So if the general partnership, for example, if it was a law firm and there was a liability suit, there was a malpractice suit, and it was unfortunate, and lawyers were held responsible, and there was a big judgment, $100 million, you could go and you could attach the assets of the law firm and take them. With a DAO, it's not quite like that. The assets can be very inchoate. They're digital assets. They're different wallets in different places. Really hard to see. So I think where it goes with DAOs, I think, is going to be. I urge all the lawyers here to get more involved to better understand it. I had tweeted earlier today, got a lot of traction, thinking about the early days of the automobile. People imagined, literally a horseless carriage. And, you could imagine in your mind's eye a carriage that just doesn't have any horses in the front. And that was sort of the automobile, because that's what people knew. And I think today we're still at the stage where we're thinking of DAOs as like CEO-less companies. Well, it's like the thing we know, but just a little bit different. And the way automobiles evolved into something quite different from a horseless carriage, I think we're still in the early days of figuring out what does a DAO evolve into. And I think that's something I'd urge, the lawyers listening and the non-lawyers listening as well, to really think about that, because I think that's very exciting and part of the real cutting edge of this technology.
That's a great analogy. I love it. I could talk to you all day about it. This is very fascinating. I guess two practical things before we go. One is that, just legislatively, where you think we're going, like what we're seeing and where you think this is going. And then somewhere before we go, in this highly uncertain world, which is, the worse than having terrible regime that is predictable. Practically speaking, what can you do to stay rational and make choices? And perhaps that somehow is tied to where you think we're going legislatively speaking.
Well, certainly on the legislative side, we've seen a lot of activity. This is a popular area. Both members of Congress and to some extent interest from the Senate has focused on digital assets. There've been hearings. The House Financial Services Committee has had numerous hearings around this. Senate Banking's had hearings. There's a lot of foment, and that's coming from both sides. One of the things about legislation, Olga, that really concerns me and I think many others in the digital asset community is what appears to be the inevitable but highly disappointing turning of digital assets into another partisan issue, and it's terribly disappointing. And I really hope we can get beyond that. So with just being very frank about it, Republicans, we're pro crypto, pro digital assets. Democrats, no, that's terrible. And look, there's so much in this area that should satisfy the perspectives of both conservatives and Republicans and Democrats and progressives. I really hope, I think good legislation will find a path through that. And I think that can happen. I'm an optimist, but I think we do have to get past that what seems to be growing sense of partisanship around.
No, the partisanship in many areas is very concerning, especially when it comes to innovation that really is tied to money. And specifically, other than sort of the stifling of innovation, one issue, but also unless and until we get all behind, there will be people left behind.
Absolutely.
And that's kind of the problem with not having good, clear legislation. So do you feel that the partisanship could be overcome to reach clarity anytime soon?
I am hopeful of that. As you and those who follow me on Twitter, I talk a lot about my own theories of how this could all come together. I do think there are ways forward that are balanced and that are reasonable to, the people that are more, innovation focused and the people who are more consumer protection focused. So yes, I'm really hopeful that, in a reasonable period of time, we will see some proposals that are meaningfully balanced, much more so than those that have come before that are much more one side or the other side. I think there's a middle ground. There's plenty of room to occupy, and there's plenty of room for people to contribute to these efforts. This is not by any means, a handful of small people in a smoky room, as it were. But I think, we've seen proposals up on GitHub. I, would expect that process to continue and really to see community engagement in what a legislative solution would look like.
We are at the end. Maybe 2-3 words. If I'm running a business, practically speaking, what can I do to make sure that I make decisions that decrease my risks in litigation, my enforcement actions, and overall, how do I think about proactively and rationally in this highly uncertain and irrational world, political world of lack of guidance?
I mean, the starting point for me is always going to be, find your inner compass, right? So much, lawyers can help, and, advice number 2 is find a good lawyer. But advice number 1 is treat people fairly. Disclose what's going on, be honest and upfront about what you're doing. If you're an innovator, yes, of course, it's wonderful to be financially successful about what you're doing. And I think we all encourage that. But be sensible and look to bring as many people into your success as possible, and not sort of be closed-minded. So common sense, Olga, is always advice number 1. How would you want to be treated if you were on the other side of something? Secondly, though, a lot of this is very dense, and finding a good lawyer who can assist you in the journey is really critical. Don't skimp on that. I think one of the challenges, many of the lawyers who are active in the space are quite busy at this time. So finding the right person may take some time. So I'd say thing number 3 as an entrepreneur is allow yourself some time. The blockchain is not going to go away. If this is as important as we believe it is, and I hope it is, right? It's going to be there in the spring of 2022. And this, sort of sense that, oh my God, there's a market window open and I've got to rush through it. I think that, will likely, or at least, make it more likely that poor decisions will get made. Give yourself some time, both to figure out what your own business plan is, what you're doing, and then to work with informed counsel and to get on there, look, and if they say, look, I'm going to have to pick this up a month from now, then, if they're the right fit, do that. So I think those are 3 things entrepreneurs can do to put themselves in a good position.
Louis, thank you so much. Definitely a very important conversation and very dense topic. And, if you need a good like Netflix and you want to see things unfold real time, I'm telling you, blockchain is better and it's free. So bring popcorn. More exciting conversations to come. I know there's quite a few listeners. Sometimes listeners are not participating. If you have nominations for great speakers to talk about where we're going in blockchain, legislatively speaking, or innovation speaking, who is working on exciting projects, definitely ping me, let me know. Would love to interview those folks so we can learn together as this is unfolding. This is a very exciting area of law. I can tell you I'm a former IP lawyer, and I will will talk about SEC unless it is part of innovation. And blockchain is how an IP lawyer becomes interested in everything SEC. So thank you so much for joining. Thank you for being active. Thank you for asking questions. Definitely let me know if you have nominations for other speakers. Thank you so much. Bye, everyone.